immediately filed motions to quash. We've tried to get some dates. Basically, we had sent her a couple of letters, but be that as it may, Judge, it's really, we've got a trial date coming up. We're getting out of time here. So we just want to be able to get this case set to trial. You'll remember that Ms. Klein and Ms. Hettinger brought their daughter in to talk to you, even though they claimed that it was just she was missing an art class or something. She actually missed a tennis tournament. And during that meeting with you, you told her, we're going to get this case tried. I'm going to get that done for you. I'm going to take care of this. And they thought it had been going on 5 or 6 years. Judge, we need to get this case to trial. Now, I think we're going to need a final pretrial where we can get all these things set for a hearing. Ms. Klein has filed about 4 or 5 more motions, Judge. We haven't filed ours yet because we were waiting for me to get back from North Carolina. But we're going to need probably 4 or 5 hours of final pretrial before our trial date, Judge, to get most of these motions heard.
Good afternoon, Your Honor. If I could make my appearance for the record, Katie Klein here representing Mrs. Hettinger, Kelly Hettinger, the petitioner, and we are the movant, Your Honor. There are a number of things that we would ask the court to address, and I do disagree with Mr. Hull that what we need is a final pretrial. I think we need a first pretrial. We have a number of things to bring to the court's attention, and if you wish to reset them for another day, that's fine. But the court will recall that we got the court on the phone because I told the court that admittedly we had not filed the motion to quash within 3 days, but that Mr. Hull had noticed my client for his office and that I have asthma and he has cats that live in his office and that I had become ill the last time that I was there. And Your Honor had suggested that you were quite sure that if we found an alternative location at my expense, that would be reasonable. And of course, reasonable is not a word that I can use when talking about Mr. Hull. I sent Mr. Hull a letter and told him that we had paid for the Mars room at the Doubletree Hotel and that we were going to be present at the date noticed, at the time noticed at 9 a.m. And he said, save your money because I'm going to be at my office and we're going to proceed. Now, how he could proceed without my client, I'm not sure. But I have since filed with the court. I've obtained a letter from my doctor confirming that I have a diagnosis of asthma, that I take medication for asthma, and I do not believe that any lawyer should be required to go to an office where there is a very well-known allergen, such as cats, in the office. And also, it is customary for the client to be deposed in the client's lawyer's office, as was Mr. Hettinger in Jesus Contreras' office. So my client and I went to the Doubletree Hotel. We sat there for an hour and a half. Mr. Hull did not appear. We sent another email to Mr. Hull after 9 o'clock telling him that we were in fact at the hotel and he was welcome to come. We had water and coffee set up, but he chose not to come. So then he sends me threatening notices saying that he's going to have my client stricken and she's not going to be permitted to testify and whatever. I mean, if he can't call my client, he doesn't want to take her deposition, I think he may have waived his right to take her deposition by refusing to drive to the place where she was present and ready to be deposed. The other two, Your Honor, happened to be based on the fact that we originally had a trial setting. We designated 2 individuals 120 days before trial as required if you're seeking affirmative relief, in case we were going to go that direction. Then Your Honor ordered that ATKG do the evaluation. So those 2 experts have no opinions and they did not proceed with any evaluation of the community. I have de-designated them and I have e-filed 2 cases for Your Honor to review, which is In re Christus Spawn Hospital versus Kleberg and Castellanos versus Littlejohn, both of which say that in the event that you de-designate an expert, so long as it's not done for some improper motive, such as to try to keep liability information from another party, that once you de-designate a witness, then the expert witness's deposition cannot be taken. So I've e-filed those 2 cases, and it's our position that we do not have to present them for deposition. In addition to which, Mr. Hull sent a deposition on written questions to Heron Levy, which is not an appropriate form of discovery. Discovery of an expert witness can only be in the form of oral deposition or in disclosures. We've de-designated the expert, so we have filed a motion to quash the deposition on written questions as it's improper. Now, as to other matters that I think Your Honor needs to look at, we have filed a motion for ATKG to update its valuation of the business, since the valuation is about 2 years old now. And we did receive the QuickBooks, and a preliminary review, a very superficial review of the QuickBooks that we received for 2021 suggests that there is a significant difference in value of the corporation and that the valuation should be updated because it's over a year old. So we are asking the court to either order ATKG to update their evaluation, which they said they are able to do. They told my client that, or to order that someone else be ordered to do that. But in any event, the appraisal of the business needs to be updated based on the 2021 QuickBooks. We also have filed a motion, we have filed a motion for continuance of the trial setting, Your Honor. Number one, because I have a motion to compel Abigail Murray to sit for deposition. I got 3 hours and 30 minutes with her as a fact witness. She's been identified as an expert, and Mr. Reynolds refuses to give me a date for her deposition, as does Mr. Hull. We supplemented our motion for continuance of trial, alleging, number one, I have a Fifth Circuit argument in the Court of Appeals in New Orleans, the notice of which Mr. Hull asked me to provide him, which I did provide him. The Fifth Circuit is not easy to reschedule cases. And plus, when you do, if you try to reschedule an argument, they very often will turn around and say, well, we're going to take it under submission, which is not what we want to do. We want to have argument in that case. But in addition to the fact that I've asked for additional time to take Mr. Hettinger's deposition because it's 2 years old, for time to complete Abigail Murray's deposition and take her deposition as an expert, I have filed a motion to exclude Mr. Hull's late designated experts. There is a motion for continuance of the trial, and then we need an order to show cause on the amended motion for contempt in addition to ATKG. So I would suggest that in addition to the motions to quash, which I think the court can take care of today, that these other matters should be set for hearing in a week or so that the court can lay out some parameters about what additional discovery the court is going to permit. And I would ask the court to move the May trial to the June date, which has previously been set as the backup date.
Judge, real quick, and I'll respond to them. First of all, with respect to wanting to take Abigail Murray's depo again, she took her deposition in 2019. She already filed a motion to ask for additional time. One of the other judges already heard that. One of the other judges says, I'll give you 1 additional hour, Ms. Klein. Ms. Murray is to designate 2 or 3 dates, and then you will take it on one of those dates before a certain date. Ms. Murray gave her, I think, 5 different dates before that date. Ms. Klein never did anything. And now here 3 years later on the eve of trial, she's asking to take that 1 hour. That's ridiculous, Your Honor. The other thing is, Judge, on this motion for continuance, I wanted to see what it was if she really did get something. We called the Fifth Circuit. They said, yes, just file a motion if you need to. I've had cases before the Fifth Circuit before, Judge. We don't even know if this argument is going to be by Zoom or not. But I've had cases where I had to move the oral argument, and they're more than agreeable to do so. We checked to see if there was anything changed since the last time I was asking for a continuance about 2 or 3 years ago. And they said, no, just file the motion. So we sent a letter to Ms. Klein telling her this is a preferentially set family law case that's been proceeding for 3 or 4 years, and it needs to go. You need to file your motion. Judge, with respect to the deposition of Kelly Hettinger, we noticed it for our office. We noticed it saying that Abigail Murray was also going to be present. We noticed it and had a court reporter, the videographer there. Ms. Klein has been into my office on numerous occasions. And just because you have asthma does not mean you're allergic to cats. Nonetheless, we put the cats out. We completely clean the office. We have a HEPA filter that's running 24/7 in that room. There was no reason why. The reason we wouldn't accommodate, Judge, is because if we move the location, she would then claim, and Judge, you don't understand who we're dealing with here. She would then claim we didn't have a valid depot notice because we moved the location. The request for production of documents we asked for, she wouldn't produce, and she would object to Abigail Murray being there, even though it was all properly noticed, properly sent, and she had more than ample time in the 31 days before the depot to get a hearing from the court. Instead, she tells the court that Jackie, I believe, that her and I want to talk to you. That wasn't the case. She did that all on her own. I get a call from Katie. I go, hello. And she goes, just a moment. The judge wants to talk to us. My goodness, Judge, that's completely improper. It was properly noticed, properly set. And the reason why we thought she'd be there is because she was subpoenaed, Judge. You can't just disobey a subpoena for no reason. And certainly she could have been there. We told Ms. Klein she could appear by Zoom. She could send one of her 3 associates or 2 associates that could have been there. We also had it set up for audio visual to be able to use in the cross-examination. That wasn't available in that room. And then she sends us a notice at like 10 o'clock at night saying, oh, by the way, because of COVID, we want to do it by Zoom. Judge, this is just dilatory tactics. Believe me, when you see the whole picture here of what's been going on, first of all, with respect to our experts, she named those experts back in 2019. We've been waiting for depot dates. We finally got dates on 2 occasions. She didn't give us one, so we noticed them. Then she files motion to quash and provides alternative dates for one of them, Mr. Harvey Levy, and then says, oh, well, no, we're going to de-designate him. But you'll note in the court's file, there is no de-designation of either one. And in fact, I could get a Rule 11 agreement with her that you're not going to, and I even said, let's get an order from the court saying that none of these people will be allowed to testify at trial and that you won't use any of their testimony and we can stand down the depot notices. No response, Judge, because what she does is says de-designate, and then on the day of trial, she'll start reading testimony that this lady gave it before, or she'll say, I'm revoking the Rule 11 agreement. She's done that in other cases, Judge. We have a binding Rule 11 agreement filed with the court, and she files her notice and says, well, we're withdrawing from it. So you've got a contract claim, but we're going forward. That's the kind of woman we're dealing with here, Judge. We've got a trial date. You promised those kids you get this case done. We want to get this case tried, Judge. And we do need a final pretrial where all these can be heard out.
Honor, I have to say that I think
hold
Mr.
on,
Holt is delusional.
hold on, before you keep going back and forth, because y'all will do that for an hour unless I stop. Mr. Holt, I know you want to get this case tried, and I guarantee not more than I do. But part of the problem is we have these motions that we still need to have heard and then something be done on them. And I don't know what the outcome's going to be. So, and I understand you're entitled to your 3 days notice before having a hearing, and trying to get hearings scheduled in Judge Maldonado's court is difficult because first we have to make sure he's free and then we have to make sure I'm free because I've got my regular docket. And so trying to find that time to be able to have all these hearings and be ready in time for trial and give you your 3 days notice as you're going to raise. And then depending on the outcome, y'all having to take depositions of more people or not, and where you're going to take them and so forth and so on. I can do all that, but I can't create more time. So if I can't logistically get it fit in, then I might not have a choice but grant the continuance, which I don't want to do. But if y'all are willing to sit down today and, go forward on these motions and, have an order come out based on rulings that I'll make on all these things that are pending, I think you could all be ready for trial on May 28th. And I'm sure the Fifth Circuit, if, you contact them and they're willing to reschedule that oral argument, we'll be able to get it done.
Your Honor, it wasn't May 28th. It's the first week of May.
The first week of May. I'm sorry. I misspoke.
There's no way we can get all these depositions done. And since the time that you ordered documents to be produced, we found out about $214,000 in jewelry Mr. Hettinger's bought since the separation.
Hold on. With regard to these other depots, so now you're wanting to bring these, you are wanting to bring these other people to testify at trial, these experts?
No, Your Honor, I have de-designated them in writing in letters that I have sent to Mr. Hull, and he can shake his head, but I have sent him letters. One of them is dated March the 23rd. That says, please, that de-designated Jennifer Edwards, and the other one came to him last week.
So then if, Mr. Hull, if she's not going to bring them, and she's agreeing on the record she's not going to bring them, then is that issue solved with regard to those experts?
No, Judge, because she hasn't officially de-designated him. She'll say that, and it's on the record. Let me finish. It's on the record, so it's a Rule 11 agreement, but she will back out of those, Judge. What we need is an order from the court that these are de-designated. That will take care of the problem.
That's what I'll do based on her agreement on the record.
But we want a basic, an order that
You
says,
can draft the order that says Miss Klein buying through her, or Miss Hettinger buying through her attorney, Miss Klein has de-designated these experts, and therefore the court will not allow them to testify at trial.
in any way, shape, or form. That's fine, Judge. That'll take care of those two.
Okay, so now we just have 2 more depots we need to worry about. Mrs.
Well, and along with that, then their documents are also not subject to disclosure. That goes to the deposition on written questions.
No, that one we have to have a hearing on, Judge, because of the fact that, yeah.
But
if
except for
if
today.
they're not, hold on, if they're not going to come in and testify, what do you need any of their information for, Mr. Hole?
Because it may be very helpful. It may show that they actually have done. And Judge, they're still billing up for it. They're still billing for it and paying BDO. That was community funds that were used to pay BDO, Judge.
Okay, well,
No funds have been paid.
It'll all get settled in the final hearing as far as who paid what and where it's going to come out of. But if you're going to want to use their documents, then I'm going to have to allow them to testify. You can't have it both ways, Mr. Hole.
Sure, and I'm not planning to, Judge. Once we get the order saying that they're gone, then we can pull it down, but not until
Okay,
then,
so
Judge.
the order will say that they're gone and no discovery with regard to them will come forward, and none of that information's coming in.
We'll draft the order, Judge.
Okay, so now we took care of those. So then we have 2 depots that we need to worry about, Mrs. Hettinger's and whatever's being claimed on Miss Murray. So Mrs. Hettinger's depot.
And we have a motion for additional time on Mr. Hettinger because it's been 2 years.
Hold on, one at a time. So on Mrs. Hettinger, okay? Is there any reason that you cannot take it at the DoubleTree or any other conference room where there aren't allergens that'll affect Miss Klein, Mr. Hole?
Well, Judge, and you have to realize that she does not tell you the truth, okay? She is not allergic to cats. I mean, there's no medical evidence that she is. Having allergies is not. That was just an excuse. But we could take it at some place if they pay for it and they have audio visual but Judge, keep in mind, you told us to produce all these documents by March 31st. We did that. My client had hundreds of thousands of documents.
Hold on the documents, one thing at a time, Mr. Hole, okay? One thing at a time. So if they produce the exact same documents that we requested, all of them without objection at the deposition, at the DoubleTree, at their expense, as well as allow my client's girlfriend to be there as we had designated before, and then we do it within 5 days, that'll take care of that, Judge, at their expense.
So much for the expert witness. It's now client's girlfriend. Thank you very much. But I have a right to make an objection to documents that are in a ducis tecum if I feel that they're covered by privilege or work product. I'm not going to, but I would have been doing that before. But we did have documents available, and I told Mr. Hole he could come get them, and he didn't choose to do that. But Your Honor, we paid $250. We can pay $250 again. But the point of the matter is he chose not to appear.
Okay,
Judge,
well, the point of hold on. We're going to go forward and we're going to get it done. So you'll pay for it, Miss Klein. It'll be where you're choosing because of your circumstances that you're requiring.
But Judge, it has to have audio visual availability.
They will cover audio visual as well.
I need to know what he wants. I have no idea what falls in the category of AV, but if he can tell me what it is that he's looking for, I'll check it out.
We will certainly do that, Judge. And also, Miss Murray should be able to be present. She was there the last time. Judge, this was a properly noticed deposition.
Hold on. I'm not there yet. We're
Okay.
just getting, we're going to agree on a place. Mrs. Hettinger will be deposed.
So because she's a girlfriend, she should come, I guess.
Hold on. The documents need to be produced. If they're not going to be produced, you need to give a privilege log as to which ones you're not producing. And then if after Mr. Hole reviews it, wants to bring it to me to decide that there are more things he needs to talk about, then I can allow for a depot next week or the following week, so that this can all get done in a timely fashion. As far as Miss Murray being there, why is it that you need her there, Mr. Hole?
Because she has a wealth of information about this case, Judge. And in fact, Miss Hettinger was there at her deposition as well. So it's not like they haven't been in the same room before, but she is also—
Hettinger, the party.
Excuse me, Your Honor. At any rate, she has a lot of information that she's done on an accounting basis that will help me to be able to assist me in the deposition. And we properly properly designated her in the motion. You'll remember the last time on the phone, Ms. Klein said, and he hasn't designated anybody else to be there. That was a falsehood.
That is
Judge.
not true. You said we're going to have a whole crowd of people that won't fit in Ms. Klein's conference room. And I said, you did not put a crowd of people on the notice.
So who else
Not
besides Miss Murray are we anticipating being there that you need there?
There's no one else on the notice.
My legal assistant, Orfa Vela, Mr. Hettinger, myself, a videographer, a court reporter, and then a person to run the audio visual. That would be
What
separate.
audio visual are you talking about?
That be the videographer?
No, your videographer is the one that was videotaping the depot. The audio visual one is the one that's going to be putting things up that'll be used during the questioning, which is why we had it at our office, because it was set up, Judge. And then she just didn't unilaterally.
I understand, but
Are we just talking about a screen? Is he going to want to use the laptop? You just need a screen, or what do you need?
I'll let her know, Judge. It would be it's something put on the screen so that.
my understanding is your audio-visual person is your assistant to be able to do presentations during trial, right? That
Correct.
puts up your different, whether it's an Elmo, whether it's whatever document you have on your computer, that person magically makes it appear while you're cueing them and talking, right?
Yes, Your Honor. So that's why you asked for the number of people.
So that's fine. So here's the deal. I mean, that's kind of helping you present your case. If there's an additional charge for that person having to come back because they didn't do then, I'll have them pay the extra, but I'm not going to have them cover your costs to prepare for that litigation and presentation at trial. Okay?
Yes, Your Honor.
So I'm going to allow Miss Murray to be there. That might kill some of his time that he's going to get to ask questions because he'll be busy conferring with her. So,
And Your Honor, with regard to Ms. Murray, we have a motion to compel further deposition of Ms. Murray. They've identified her as an expert in the notice to my client. They said she's going to serve as an expert. When I got her deposition, she was represented by Mark Walker. He instructed her not to answer many questions. And in addition, at 5 o'clock, more or less, he said, I'm sorry, I'm leaving, we're done, I gotta go. And I was only 3.5 hours into her deposition as a fact witness. I've not gotten an opportunity to ask her any expert questions. So I need another 6 hours with her. She's not a party to this suit, but she is the one who writes all the checks over there and the recipient of $200,000 worth of jewelry over the last 2 years. So that we've now finally got the Van Cleef and Arpel list of jewelry that's been purchased. And I need to ask her about that.
okay, here's what I'm going to do.
Your Honor, can I say something
Sure.
quick? Number one is everybody's been deposed here. I've been deposed, okay? And just because somebody deposes somebody when they shouldn't doesn't mean that you can depose them again 2 years later. I mean, I don't understand that. I sit here and I listen to just lies come out of everybody. I'll be honest with you. I have not said a bunch of stuff. I listen to everybody talk. I do whatever you tell me to do, Your Honor, whether it's with money. And yes, it hurts. Obviously, I don't have to tell you anybody on this thing about that. But to sit here and just listen to, oh, he spent $218,000. He did this, he did that. It's just total lies. And to sit there and have you listen to it and put this into your head, not knowing the other side or not hearing the other side is just ridiculous. And this woman has been doing this all along through this entire case for this entire time. And really, I'm actually looking forward to being in the trial because it's going to be a very big eye opener for you and everybody else who's been sitting here listening to everything that's been going on, because this has been nothing but a ton of bashing on me ever since the beginning. And it's really, it's been years. Now you hear COVID is starting to ramp up again. I'm afraid the next thing you know, she's going to say, well, we can't go into a courtroom because now we have COVID again and we can't get a jury trial. And then we got to wait another year. So if we don't,
we're not going to wait.
It's never going to get done.
We're not going to wait another year, but I'll tell you this, Mr. Hettinger, just for your benefit, there are 3 sides to every story.
Yes.
Each individual that's opposite, and then there's the whole truth. And typically, I never get the whole truth. And it's not that you're intentionally lying or misrepresenting the facts. It's just that you're going to look at that wall behind you and say it's some shade of green. Mrs. Hettinger is going to say it's a different shade of green. Ms. Klein's going to say it's a different shade of green. And Mr. Hull's going to say it's something else. It's everyone's perspective. So it may not be that there's an intentional lie. And of course, anything that anybody says to me is not evidence until it comes out in court before a jury, and a jury's going to hear that evidence and a jury's going to decide. I've been doing these cases long enough to know when people are telling the truth and when they're lying, and it all has to be backed up by evidence. So if they're claiming that you're spending $200,000 worth of jewelry for somebody, they're going to have to come and prove it. If not, then the person that they're asking to believe it is going to have to question in their mind, well, is it true or not? Because it wasn't very clear. And so that's why we have a jury that'll decide based on people's testimony and based on documentary evidence what in fact is the truth. Because at the end of the day, the jurors are going to decide what the truth is, regardless of what either side's putting out there as being the truth. They're going to determine your credibility, and they're going to determine what weight they put on each of y'all's testimony. It'll be up to them. So don't worry about me getting swayed one way or the other on any of this. I tried to get y'all to settle this way back when to avoid all this. And, unfortunately it didn't work, but we're going to get a jury to tell you the results in the end.
Your Honor, on our Abigail Murray motion, like one of the examples was, I said, do you think it's appropriate for one community property partner to spend hundreds of thousands of dollars traveling with a girlfriend to the detriment of the other community partner? Mr. Hull, objection form. Mr. Walker, objection form, don't answer. And that's what we went through all afternoon. Don't answer, don't answer, don't answer. If Mr. Walker didn't like the question, he instructed her not to answer. That is sanctionable, and it makes the 3.5 hours that I spent with her much less valuable because of all these. Another one is like, I asked her about, do you know about ethics? Do you think it's wrong for you to be lying to my client about having an affair with her husband? Don't answer.
Well, hold on. With regard to that witness, we need to have her lawyer here so that I can give instructions so that this doesn't continue to happen. So let's not talk about her yet because she's not here. But if you want to have that hearing before you actually depose her, I'm glad to try to find some time for you here in the near future.
Do you know when the court would be available?
Not yet, but with regard to Mr. Hettinger's additional time for testimony, I'm going to give you 1 hour, and that's it.
Then do I get 6 hours with Mrs. Hettinger? Do I get 7 then?
I'll give you 7 with Mrs. Hettinger, to be fair, Mr. Hull.
Thank you, Judge.
Okay.
Your Honor, if I could just be heard, my client is not the one in possession of all the financial documents. To spend 7 hours harassing her about anger management when she's not in possession of the financial information is really extreme.
Ms. Klein, you chose when to depose Mr. Hettinger, and you took all that time then. So, I'm giving you an extra hour, and I'm going to be fair to the other side and give them 1 too. So that's just the end of it.
I understand. We did have an earlier trial setting, Your Honor, but that we'll deal with that later.
Okay, so what other issue do I need to take up so that we can get this thing teed up for trial?
Updating the evaluation of the business with ATKG, if the court would permit that.
Judge, here's the problem with that. We had an agreement that we would be bound by what they came up with, okay? And then you said at that other hearing that, well, no, that's been too long. It needs to be updated, so no one's bound by it anymore. You all go get your own experts. You all fight it out. We got our expert, and we named him immediately as soon as we got word that we couldn't use the other one, Judge. And so since then, we produced them. We produced their reports. We've done it timely. They haven't produced anything, and that's going to be another subject to a motion to strike. But bottom line, Judge, is, I'm sorry.
So now you're wanting to use an expert, but you don't want me to let them use an expert.
They could have used anybody they want. They can't use ATKG because they have a conflict of interest. They have a letter of intent with both of us, Judge. We were both agreed to be bound by him at that time. That's why they named Mr. Levy. And in fact, she even gave me depot dates for him because I assumed that was going to be their expert. But they just de-designated him on the record now, Judge.
I
But the
don't know
bottom
who
line,
Mr.
Levy
is.
was designated before there was an ATKG. Levy was designated in 2019. We agreed to be bound by the ATKG valuation as of the time that its period of time ended. Another year has gone by, and we're asking you to order ATKG to update their work since they're more familiar with the business than anyone else.
no, that's not true, Judge.
That's not true.
And they also provided us in 2022 dates for Mr. Levy's depot. So it's not like they didn't know that they had to come up with an expert. But ATKG cannot be an expert for either side in this case, Judge, because of the fact that at this point, they were letters of intent with both parties, and now they can't be just one. We paid half their thing when we were in it because we had an agreement. But as the court said, you know, too much time has passed, Mr. Hole. I'm sorry, we were supposed to get this done earlier, but no, you're not bound by that anymore. So we went out and got our expert, and we got it done, but by the court's deadline. So
well, if that's true, then they have violated the rules. They've not provided us with the substance of the opinion of their expert, which has to be done 120 days before trial. They have provided us no information concerning their experts' opinions, so they're subject to strike, and I have filed that motion. But I'm asking the court to have the court's expert update the information in response to this request, because Heron Levy said, I cannot possibly do it in 40 days. It's impossible for me to do it. The court ought to have ATKG update the work since they already have it set up in their system, and they can feed the information in and give a supplemental report.
The court cannot intervene in a case and appoint an expert. You did it because the parties agreed to be bound by their decision as of the end of December 2020. And that's gone now, Judge.
Okay,
And we didn't even agree to it, but we agreed to it. Get this over with. I agreed to getting them to do the evaluation. And then I even agreed to their evaluation number in order when we went to the mediation. But then I went out and we had to go out and get a secondary opinion regardless, after you had mentioned to us that this was not the right that we could,
that no one was going to be bound by
no longer count it. And so we did go out, but I never agreed to ETKG's evaluation. I did it with you that day that we went to the side with myself and my wife and you and your assistant court coordinator. And I agreed whatever they came up with, fine. And I stuck to that. Did I agree with it when I actually saw it? No. And I've been through a lot of these things, especially an extremely large one with much more larger companies like PwC, PricewaterhouseCoopers, and other companies that have done evaluations. And I didn't think they did that great of a job. So I did do a separate one. So I think ours should be admissible because it is a very good and very well knowledge company that can testify on our behalfs. On this.
Maybe that's why Mr. Hettinger hasn't paid his bill. Excuse me, I'm speaking. Why Mr. Hettinger hasn't paid the last $1,800 of his bill. But the point of the matter, Your Honor, is that if we are going to be required to get an expert to do an updated evaluation, then we need 90 days for that, not 40 days. Apparently, he said it was impossible, but he said ATKG could do it, and ATKG told my client that they could do it. So the court can allow them, by expanding the scope of his order, allow them to update their evaluation.
Judge, the order was an agreed order. There is no agreement anymore. It wasn't bound. We were agreed to be bound by it, even though it was like $1 million or something high, but we had said, we gave our word. Now, what they're trying to do, Judge, is continue the case again. Everybody knew this trial setting. Everybody knew the dates, and everybody knew what to get done, Judge. You promised those kids you would get this case tried in May. If the very latest.
Not get the information until the end of last month.
I am talking, Ms. Klein. And so, Judge, what we need to do is, just because they screwed up and didn't get their designations done in time, just because they're trying to get the court to appoint an expert for them, that's never happened. The only reason you did was because it was an agreement that was reached. They jettisoned that agreement. So we're now
Which-
on our own, and we got our expert. We designated them timely. We provided
No.
full reports from them, Judge. And so
It's
we're ready to go.
120 days, Mr. Hole, and you know that, and your expert was not designated 120 days early. But Your Honor, all
We're
I'm asking you to
defending.
do is expand the scope of your order to
Can't do it.
permit that
All right.
HTG, and
Here-
I'll do it at our expense. We'll do it all at our expense.
Here's the deal. This is what we're gonna do. The intent while neutral evaluator come in that neither side picked, that you would have something that you could work by. And I figured that would help y'all reach an agreement. But if it didn't, you've already paid for all that work. So I don't know why you wouldn't want to continue to use that.
Because they're wrong.
Okay, well, and that's fine. If you don't want to use them, that's fine. That's money that y'all spent. But at this point, I'll either allow Ms. Klein to redesignate her other experts in order to be fair to her client, or I'll let her have ETKG update their valuation at Ms. Klein's client's expense.
We'll take the latter, Your Honor. We'll have ATKG update at our expense.
Judge, they
Does that
can't
mean we
ethically
can-
do that.
What?
They can't ethically do that. They have a letter with Mr. Hettinger, the letter that they signed.
No,
I mean,
their instruction is to update it, not favorable to one side or the other, just current numbers.
Does that mean we can bring in our experts that we've paid for already?
Yes,
Not timely.
you'll get to bring in your expert, but I can
Your Honor,
either
they're not timely.
I'll give you the choice on either let them have ETKG update theirs or have separate experts. And then that might push your trial date.
Yeah, because Your Honor, the rule says that 120 days before trial, that the parties seeking affirmative relief must provide a substance of the expert's opinions, and they have not. And we're within 120 days.
they were the ones seeking affirmative relief. She filed the divorce. We're not the 120 days. Our designation was timely, provided reports timely, Judge. But
They
but
have
if
a
you're going-
counter
Judge, excuse me.
petition. They have
Judge,
a
if you'll go
counter
ahead-
petition.
If they can go ahead and, have ATKG, which we vehemently oppose, but if you're going to let them do that, then our experts should obviously come in.
Well, that motion's
We
not
named
set
them
for
as
today.
soon as- Judge, we named them as soon as we found out that we weren't going to be bound. We were under the impression everybody was bound because that was the agreement.
We are bound by the evaluation
No,
as
we
of
are
the
not.
date that it was first ordered.
No.
You either
Well,
go
that's
by
for
the
the court.
valuation that they
That's for the
provided.
court to
Here's what
decide.
I'm gonna do. I'm gonna make sure I limit the amount of error in this case. So I'm just gonna allow you to designate Ms. Klein, not ETKJ. You could designate your witness and get the report done and get the work done sooner than later. And
We can't get it done in 40 days, Judge. So do you want me to get an estimate?
with it,
Want me to get an estimate of how long it will take?
yeah, get an estimate and we'll find a new
Okay.
trial date for you.
That's fine, Your Honor.
Judge, we are not agreeable to that. Just because she didn't do it timely. Well, Judge, we said, if you want to let ATKG come in here, we can cross-examine them on ethics day and night. So if the court wants to do that, let them.
That's why I'm not gonna do that. I'm not gonna put ETKJ, whatever their name is, through the mill.
But Judge, here's what's happened. Because Ms. Klein and Ms. Hettinger didn't designate like they were supposed to, now they're going to put off the trial date. When you promise these kids you get it done. This case has leaked attorney's fees, Judge. It is unreasonable. We tried to get it settled. We have taken 0 depots, Judge, 0. Ms. Klein has taken all the depots in this case. We need to get this case tried. If we're not,
I'm gonna let you take depots. I need a quick recess. We're gonna take about a 2-minute recess.
Yeah. Then it's up to, then it's. I will.
All right, I'm back.
Hey, Your Honor.
Yes.
Hey, you know what? I'll instruct to what you call it that he can't, cross-examine and critique ATKG if they want to use them. I mean, obviously they've been talking to them a lot. I can see that. But the bottom line is I don't want to stall this. I want to get this over with. I know you want to get this over with. I know you met with my daughter. I could read in the transcript. It was sort of like heart-wrenching reading it. But at the end of the day, I mean, I want to get this done. If ATKG wants to go in there and be their expert because they've looked at everything, I'm fine with that. And I'll instruct Ron that this is the way it's going to happen. But when from our last case, our last place, I was basically under the impression that ATKG was out, but it seems to be that these guys have been obviously sending them information. And, I want to just roll forward on this. I do not want to sit here and drag this out anymore. It has been so long. It's just ridiculous. And the amount of money this is costing for both myself, everybody, is ridiculous. The waste of the time for this court, everybody, and the only people here are benefiting are the other people that are sitting on this call or this Zoom. And if that's what it's going to take, then that's what it takes. And I'll do whatever, and I'll instruct Mr. Hole to do whatever.
You already ruled, and Mr. Hettinger cannot
Thanks for
instruct
interrupting.
his lawyer in such a way that it eliminates what Mr. Hole has already contended is error. And one more thing about my client's deposition. The last time Mr. Hole was in the presence of my client, he called her a bitch. And I want the court to direct Mr. Hole to not be using profanity toward my client at her deposition.
Your Honor, I did not say that. I never heard, I don't even know what she's talking about. She sent me a letter saying that.
And
So
you
maybe
don't have to be such a bitch when you were at her house for the inspection and everybody heard it that was there.
Well, I don't recall that, Judge, but bottom
At
line,
Andrew's house.
I agree.
At Andrew's house.
Excuse me. I agree not using any profanity, Judge.
All
I
right,
think what
I'll
my
tell you
client
what, if
I think
profanity
it was
is
witch.
if profanity is used, you could stop the depo right then and there, and it's done. Okay,
Understood,
Mr. Klein?
Judge. Now,
All
Judge,
right,
with respect
so-
to the ATKG, I understand what he's saying. And so what we're saying is we would be agreeable then to letting you have them update it. And I will not cross-examine them at all about it being unethical, because it's not that important to him to get this case over with, because the kids are suffering, Judge. Maybe they don't care about it, but we do. And so we need to get it over. If they give us a report that's 5 million off, then I'll deal with the numbers, Judge, with our expert. But we don't want to put this case off.
All right, so you'll waive any issue with regard to any arguments with regard
About
to?
them updating the report from ATKG. That's correct, Your Honor, on the record.
Okay. So does then that cover any issues that are left for now?
Yes, Your Honor. And then, of course, that also covers their motion to strike our expert as well, Judge.
Oh, it doesn't cover it, Judge, because you haven't heard it yet. But the
Judge-
issue, we'll have to reschedule the matter pertaining to Abigail Murray, Your Honor, as far as her serving as an expert and as far as her unwillingness to answer questions. We have a motion to compel her to answer questions. So I need a date. I need to have a date when Your Honor can hear that, and we can let Mr. Reynolds know what that date is.
Jackie,
Is the court now authorizing ATKG to be the plaintiff's expert?
No, Judge.
No.
What I said was if we are allowed to have our expert. Now they're saying they want to strike ours and only have ATKG? No, sir. That was only if we were going to be fair, Judge. And you said our expert was not going to be untimely, and they got to do ATKG untimely. So it's either
No.
one or both, Judge. Neither both or none.
That motion has not yet been heard, the
We're hearing
motion
it
to
today.
exclude their expert.
These motions weren't supposed to be heard either.
Ms. Klein,
Your Honor, could you direct Mr. Hettinger that he's not an attorney of record in the case and he shouldn't be offering his opinions?
Ms. Klein, so allowing ATKG to update their report is basically gonna give us what y'all believe is a fair assessment, right? Or do you think your expert would come in?
That's
at a
correct, Your Honor,
higher-
but I cannot go to trial without an opportunity to depose Mr. Hull's expert and to get his report or the substance of his opinions, because he's
Okay.
not complied with Rule 194.
So, Mr. Hull, has your expert drafted a report yet?
Absolutely, Judge, and served it to 30 days, more than 30 days before trial. And it has all their information in it. It was quite thick. We've given that. And
Ms. Klein was given that?
yes, Your
No.
Honor. Absolutely, she was.
Okay, can you?
I don't know
make-
where it is. I haven't seen any
was
report
in a-
come in from his expert.
It was in our supplementation to our request for disclosure.
I think well, I'll go look again, but we've looked at everything on the flash drive.
Judge, I get comments from her all the time. Will you respond to my letter when I've responded to it 3 times? I don't know what's going on at her office.
Show her where you sent it to her and then she won't be able to respond,
I
okay?
I
will,
don't
Judge.
think it was on the flash drive.
Well, then there you go. Mr. Hull sent
It
me a
was sent
flash drive. and
before,
I'm
it
so
was
used
sent
to not-
before, it was sent before that, wasn't it,
No,
Rob?
it was not. It was not, Mr.
Then it
Hettinger.
was
You
on
don't
the-
know
Hold
when
on,
this.
hold
It was on the
Hold
flash drive.
on. He'll be able to show where he sent it, if he sent it attached with a letter, certified mail or confirmed email receipt. There'll be a way to show if it went or not.
Yes,
Okay,
Your
but
Honor.
in any event,
Because Mr. Hettinger says it was sent before. Mr. Hull says it was sent with the supplementation. So I have no idea.
in any event, Mr. Hull, if you are gonna use that witness, I'm gonna need you to have that witness available for a deposition before trial.
Sure, and we need to get, and we've previously requested depositions for ATKG's deposition. And so we get that first because they're the plaintiff. They're the
Well, they're not-
petitioner,
They're the what?
the petitioner.
It's not my
You
expert
always
according
take
to
their
the court.
expert first, Judge, and then ours.
Apparently, I don't have one. I have ATKG.
That is your expert. That is not, and they cannot refer to this as a court neutral expert, Judge.
Mr. Hull, I'm the one that found that that firm, and that firm got information from both sides, mostly I think your client side, to comprise their report. So their communications were supposed to be 2 ways every time, copying both sides so that there would be transparency and there wouldn't be any question as to which way they were leaning based on only communicating with one side or the other. And that's what I ordered them to do from the beginning so that the issue would not arise. And so allowing them to pay for the update, you can argue that as the number being wrong or not, but in the end, I don't see why a jury isn't going to put a lot of weight on their opinion because there's somebody that neither side chose. Somebody that was paid equally by either side until this very end. You know,
Well, Judge, that's the problem with it. They've had communications with them from looking at the billing. They've been talking to them all along, Judge, and we haven't. But anyway, okay.
I don't know what the communications are, but you know, we either are going to be able to go forward on these issues, or I'll just let each side bring their own experts and we'll fight it out. Whatever y'all want to do. And I'll make it done sooner than later. If that means bump the trial 30 days to give them a reasonable time to get their expert up to speed, then that's what it'll be.
And Judge, we've received no expert report from them as to ATKG. So them complaining, we give yours.
Because
Their report was the report of the valuation of the business that both sides received.
they weren't retained by anybody other than both sides to give a valuation. So you should have gotten that valuation. I don't know if you did or not.
That's not the one that they're going to use at trial. If they are, then we don't have a problem.
Well, they're going to update the numbers. They're going to say since whatever
that's a new
date it
report.
was, this is how much more income came into these companies. And based on that, or this is how much less income came in this last year. So based on that, we value the business a little bit more, a little bit less. I don't see it changing that much.
Well, then that's a new report, but we have not received that, Judge.
Well, I don't know that they have it.
It hasn't been done because neither of us had the ability to retain them to do that, Mr. Hole. You know that.
Judge, we've got our expert. We named ours timely and we produced a report.
Okay, I'm going to allow Ms. Klein to produce an expert. You guys can each depose. And how soon can you have an expert report, Ms. Klein, not ATKG?
Well, if we're going the other direction now, I think it would probably be 90 days, Judge, because we're just finishing taxing.
60 days to have it ready and have that witness deposed.
Okay.
So we're going to need a trial date the middle to the latter part of June, Jackie.
We do have a June alternate, Judge, we could probably go with.
The June alternate date?
60 days.
What is the June
Oh,
alternate
yeah.
date, Orphe?
The middle of June.
June 13th, Judge.
June 3rd. Is that when that alternate trial date is?
Yes.
That's exactly 60 days.
Perfect. That'll work, Judge. Like I said before, I have two other trials, but this one will be preferentially set. So we'll go forward with this one. And that'll take care of her Fifth Circuit thing then too, Judge.
Right. So these other issues on deposing Miss Murray and getting her counsel here, let's get those motions set. Jackie, do we have a day next week when we can do that? That you're available?
The day that I have available, Judge, is next Friday. We can log in. Well, do you want it in person or via Zoom?
Y'all want to do it Zoom or in person? I'm fine either way.
In person, Judge, if it's not too much trouble for you to come up here.
I'm fine with Zoom, Judge. I don't know if Mr. Reynolds wants to drive down here, although an insurance company pays him, so he might not mind. But he might have difficulty getting here on 1 week's notice. I don't know.
Judge, what I know that in talks with Priscilla, your assistant, I do need to get in contact with her to check your calendar, and I can check our calendar. And once Ms. Klein and Mr. will submit their orders, we can send them out.
Let's do this. Let me have Jackie get with Priscilla and make sure that I'm available, and we'll give you a couple of options in the next week or so. And we'll do it by Zoom just so that it's easier for people to attend, and that doesn't make it more difficult.
Yes, Your Honor.
And so it's going to be the motion on Miss Murray's deposition, and what else were y'all needing me to decide?
Your Honor, I need you to sign an order to show cause on our amended motion for contempt about Mr. Andrew Hettinger going around the children drunk and about other violations of the temporary orders. That motion has been on file.
We already had a hearing on that, and you had a breathalyzer thing. He's doing that all the time, Judge. It's already done.
The amended motion pertains to other allegations that were not heard because the court only allowed us to go on the ones that were currently pending. And
in the end, if it's going to be him on a monitor, what's the point?
The jury needs to know that he's been found in contempt of court if he is, when it comes to whether or not he's going to continue to seek custody of the children.
Judge, that's
Are
ridiculous.
You seeking custody of the children, Mr. Hettinger?
Yes.
Okay.
But Judge, I mean, do we have a motion for contempt for her failing to comply with the subpoena? We're getting lost in the weeds again, Judge. They're talking about things that happened like allegedly 2 years ago.
Well,
You already heard it.
I'll try to find a time to hear your motion for contempt before the trial, but it'll have to be in person in order to have that. So
That's fine, Judge.
Judge, just so they can have the sale to the jury, he's been held in contempt. Should we then find a motion?
Mr. Hole, he has
Yes,
to be found in contempt first.
right. But I mean, why are we wasting time on stuff like that?
Well, y'all get to file motions and I have to give y'all hearings and hear evidence.
Judge, look at the number of motions we filed. Look at the number of depots we've taken. Look at the things we've done. It's always defensive because we've been trying to get this case done and keep attorney's fees down. But I will file a motion for contempt against her. Don't you worry. And we'll have that set too. If that's what the court wants to do. I think it's ridiculous to set it. You already heard it, the motion for
If
contempt.
that's what y'all want to do, I don't pick what motions you file. I mean, if it was up to me, I wouldn't hear any motions. I'd just say, let's show up and let's have a trial.
I'm with that,
Let
Judge.
people
Let's do it.
decide. But y'all file motions, I have to give you hearings and I have to make rulings unless y'all agree.
You keep saying you all, Judge. That's not
You
the case.
have
They're the ones that
every-
are abusive.
Mr. Holey, you have every right to file every motion you want. If you want to file a motion for contempt, you can do that. Remember, in the end, the person that sees everything that's going on is making a determination and making an opinion about what's going on here. And so, you're going to live with whatever opinion those people form. If it looks like you're just doing things just to do things and cause, issues and problems, that gets churned into the decision-making process when it comes time to make a decision.
I think I understand, Judge. Thank you. We'll do that then. We will not be filing a motion for contempt.
All right. So we'll get you that set in person and we'll have a hearing. And if the evidence shows it, it shows it. And if not, it's denied and we move forward.
Thank you, Judge.
Okay, so Jackie will get with your offices on dates that we can have a Zoom hearing to determine the issues on Miss Murray's deposition. And then
And should we hear something by the end of the week as far as the dates?
probably by tomorrow, if not the end of the
Okay.
day. It just depends on
Thank
how
you,
busy
Judge.
it is right now.
So now we are officially moved to the alternate trial date of June 13th.
Yes, by necessity.
Okay, thank you.
And I'll let ATKG know that they're done. They don't need to participate any further.
Thank you, Judge.
Well, they will be allowed to be deposed for purposes of letting the jury see their methodology and what their conclusions were, correct, Judge?
Absolutely not.
I'll let y'all offer the report as it was done back then. But since nothing more is going to be done, your expert can give their opinion as to how it changes going forward. And just like Mr. Holes will give an opinion as to how it changes or how it was invalid or whatever. But
So the court will not permit a face to be put with the name of ATKG for some face to explain the report, Judge?
No.
I don't think we need. I don't think we need a.
All right, then may my expert have an opportunity to confer with them about their methodology, because otherwise he wouldn't be able to explain it.
I mean, your expert can do what your expert needs to
Okay,
figure out how their own report's going to be. So they can't just take ATKGs and say, this is my report, unless they want to adopt everything and try to defend it. But I mean, that'll be up to them.
okay.
All
Judge,
right?
can you make sure that the orders are approved by both sides? And if not, then we both send our orders to the court.
That's fine. And I'll just make clear so that it's clear in the jury's mind kind of how this happened, that if you are going to put ATKG's report in evidence, either side, it'll be explained to them that this was a firm that, in an effort to try to reach compromise before getting to jury, was not selected by either side, but by the court. And they came up with a report, but then there was no settlement. So each side brought their own expert going forward.
Very good, Judge.
All
All
right.
right, thank you, Judge.
All right.
Have a great day.
You too. Take care.